Our first case this morning is in re J.A.C. In light of his upcoming departure from our court, Justice Pierce is not sitting on cases for oral argument. And we're pleased to be joined by Judge Camille Nider of the 2nd District, who will be sitting in Justice Pierce's stead. Before we have counsel enter your appearances, just a couple of notes. I think you're all familiar with this, but for the record, we've allocated 20 minutes to a side, but we'll continue to ask questions as long as we feel like it would be helpful to our case. In that event, if your time expires, please continue to respond, and you need not ask permission to do so. Any such time will not cut into rebuttal time. That may mean that at the conclusion of the argument, one of you will have had more time with us than the other. That's just a function of how many questions we've had of your issue with respect to your issues. Not a comment on how we might view the relative merits of the arguments. Okay, with that, let me ask if you would please enter your appearances.
Alexander Marshall and Kirsten Norman for the appellant mother.
Welcome.
Martha Pierce, attorney guardian ad litem for the minor children.
Welcome.
John Peterson, assistant attorney general for the state of Utah.
To have you with us as well. Okay, well, let's jump into it.
Good morning, may it please the court. Every one of mother's due process rights were violated in this case. The question for this court is not if you should reverse, but how. We made 3 categories of arguments in this case: due process, reasonable efforts, and best interest. I'm going to cover due process and best interest in the interest of time, but of course you can draw me to any area you have questions about. To turn to due process, there were 4 distinct due process errors. First, mother was excused from the case before the children were removed, and she was not really explained what that was. From the colloquy in the record, the only fair inference is that mother thought there would be no adverse findings against her, and that there was no need for her to attend anything, even though she offered at the time to attend virtually if that was possible. That was dismissed by the court. Coming from that error were multiple additional due process errors. The most pernicious was the lack of counsel. She had filed an affidavit asking for indigent counsel before that hearing where she was excused. She never said she didn't want an attorney. She was never told she wouldn't get an attorney, and she was never given an attorney. She then filed an affidavit 2 more times before she was finally assigned counsel 18 months later.
Can you help me understand what were the adverse findings that were entered against her while she was unrepresented or when she didn't have notice of the hearings?
Yes, so starting from that very first hearing, the first adverse finding entered against her was that she had waived counsel when she hadn't.
Right, I'm sorry, when related to the children.
Yep, so then going from there, there was a shelter hearing. At the shelter hearing, it was found that the children could not be safely returned to any parent. She is a parent, and so that was an adverse finding against her. Then at the adjudication, she was
Can I just, before you move on that first one, was that actually found against her, or was that in the proceeding with the father?
They're one and the same, and the way this was treated. So even though she wasn't there, this is part of the problem, right? Is that the court sort of treated her like she didn't exist, but then also all of the findings cut against her. At the point, if it was the proceeding just as to the father, for example, in a normal situation where you have a non-custodial parent, if the court had found we can't return to the custodial parent, it would have automatically turned to the non-custodial parent. That didn't happen here.
Okay, and was that determination made when she was out of the country?
Yes.
Okay.
Do you know if there were efforts to make sure that she knew that the shelter hearing, I mean, let's get past the service issue with the initial or with the petition for removal. The shelter is something that is separate of that, but very immediate after that.
Yes.
Do we have any idea if there was notice attempted to reach her?
There was no notice.
Okay.
There was no notice of any hearings until after she came back from Turkey.
Okay.
So they were served on her address where father lived, but she was obviously not there, and DCFS knew she wasn't there. The court knew she wasn't there. So she would never got any rule-abiding notice of any of the hearings. Certainly didn't get a summons for the shelter. She was not aware the shelter happened. She found out her children were removed from father during a phone call with her kids, and she then called the state, which the AAG says at the adjudication hearing, or maybe it's pretrial. The AAG says mother called, concerned that her children were going to be adopted. So that's how she finds out. It's completely non-legal methods.
So it's really helpful to have experts like you all in this area to explain how all of this works, because I'm not an expert in juvenile law. So once the children are removed at the shelter hearing, like when she came back to the country, what effect did that adjudication have on her? Could she have when she returned to the country, could she have contacted the court and said, I'm available now to take custody of the children? How does that work?
She did.
Okay.
So she came back right before the first permanency hearing. So to give the brief overview, you have shelter. Adjudication is where the court takes jurisdiction over the children and makes findings of neglect, which happened in default in this case against mother. So findings against mother were entered there. That was one of the most. At the adjudication.
Adjudication. And that was against the mother?
That was against the mother, yeah, in default.
Okay.
Then you have review hearings that happen. There's various findings that can be made at those points. There's also, sorry, I skipped one. There's a disposition right after the adjudication. That is where the court, and this is very important for this case, decides whether or not it's going to order reunification services. So at that point, the case can take one of two tracks. It can either go into a reunification phase where the parents work services and hopefully get the families reunited, or it can go non-reunification, which generally is a fast-track determination. And in this case, although reunification services were ordered to both parents, the court proceeded as if it had never ordered reunification services to mother, and in fact stated that multiple times, even though that was not what the court ordered after the disposition.
But, as a practical matter, reunification services couldn't have been offered when she was out of the country, right?
So there's a difference between reunification and reunification services. Reunification is a goal of the case. It means that the court, no matter what is involved in that, is focused on getting the kids back to the family. Reunification services is what DCFS can give you. What can they pay for? What kind of things can they provide to the family to support the goal? Even if reunification services were not available to mother, reunification as a goal absolutely was.
So I thought I apologize, I thought you just said that was the goal as to mother.
It was the goal in the order. It was not how it was treated by the court.
I see, okay.
So the court just treated it as if that wasn't possible because she was in Turkey, which even taking that by itself, she's just an out-of-country parent. They're out-of-state parents. Why not an out-of-country parent? They never considered, maybe we can send the kids to Turkey. Maybe we can figure out how to get mom back. None of this conversation ever happened with the court. The other thing to remember is by March, so the kids are removed in October. She finds out in November. By March, we have the COVID pandemic, shuts down all travel. But it also makes everything go online, including DCFS services. No parents were doing anything in person at this point in time, which meant all services were actually available to mother. They just needed to be provided. She just needed an internet connection, which she definitely had because she had visits with the kids over video from Turkey.
And is that different than it was before COVID? Because none of us can remember pre-COVID very well.
Yeah,
but,
none of us do.
Could she have appeared virtually before the pandemic?
It was not common. It probably happened, but it was probably very rare. Okay. She did offer, regardless, she did offer to appear virtually, and the court said, well, that'll be hard with the time zones. But certainly at the point of the pandemic, everything was virtual. All of the hearings were virtual. She just needed the link. She was never given the link. She was never told when they were happening. The only thing she was told about, and this was, it seems a little unclear from the record, but it seems like she did manage to participate in child and family team meetings virtually from Turkey. So she was in contact with DCFS. She just wasn't getting notice of the court proceedings, and she wasn't allowed to participate in that. So that's where the due process concerns come in. And
When you
remember,
say she wasn't allowed to participate, did someone prohibit her from participating?
one time they did. So
Tell me
when
about
she
that.
finally got back, she gets to I think it's the first permanency hearing, and it's online. And she's there, and she's trying to put in via chat the things she's doing, because at this point, she has found therapy by herself, she is attending by herself, she's paying for it. She's trying to tell the court, hey, I'm trying to do these services, I'm trying to comply with the plan, because that's the question at permanency, is whether the parents are complying with the plan. And the court says, we're not dealing with mother today, so we're not going to listen to what she has to say. So she's effectively precluded from participating in that hearing, still unrepresented.
At what point does she become represented?
After the second permanency hearing.
What's the timeline on that?
It's February of 2021.
Okay, and does her lawyer come in and say, wait a second, she didn't get a lawyer before this adjudication, she was not getting notice when she was in Turkey, there are all these due process violations that you've described here, and this is a problem, and we need to do something about it? Did the attorney raise those issues?
Not immediately. They were raised at the termination trial. So
In the closing argument?
In the closing argument, she talked about them at the trial, but they were raised in the closing argument for the most part. The problem with there's an ineffectiveness claim there, which is part of what we talk about. The fact that this wasn't raised earlier is ineffectiveness. Putting that aside, though, even if counsel had raised it at that point, those kinds of objections need to be specific and timely. And at that point, we are so far past an adjudication, so far past the main points of this case, that it would have been almost futile.
But help me understand that. That's where you've lost me a little bit in your argument.
Sure.
I mean, I can see the problems that you've described, and this certainly was far from a perfect process. But when I look at it, you say, well, obviously, nothing could have been done at this point. But I look at the record, I look at the trial, and I'm trying to figure out, looking at the evidence that was provided there, what would have been different? Help me understand if she had had that objection made earlier, if she'd had the lawyer earlier, how can I discern whether or not something would have turned out differently?
So there's a couple answers to that. The first one is taking the timing of when the lawyer comes in. So the lawyer comes in after second permanency, which child welfare works on a timeline, right? There's a clock ticking, and at that point, the clock had run. So the lawyer, from the lawyer's perspective, there's not a whole lot to be gained by trying to go back in time because the clock has run. There's nothing really to be done about that. That is a massive amount of prejudice that happened. The fact that she was denied reunification all through when that clock was running is a massive problem for her, but it's not one that can be undone.
The problem I'm seeing, though, is wouldn't it have been better to deal with that then than to deal with it now 5 years later?
Oh, certainly.
So it seems as though something could have been done at that point, right? You're asking us now to do, I'm not even sure, an entirely new trial, including adjudicating abuse and neglect, is that right?
So, no.
Okay.
Not quite. And this is admittedly a difficult problem, and this is part of why the structural error argument is so important, because we're talking about a compounding proceeding, right? It builds on itself as it goes along, and then we get to termination, and so much of what happens at termination, both the original termination trial and the remand part, is based on what happened during these initial phases. So it's all connected. And the structural error, the reason why we argue structural error is exactly this concern, is that how do we unwind this clock when this has happened? And we have case law with the finality rules the way they are, drawing a sort of line roughly at adjudication. And I say roughly because it's not consistent in the case law. Sometimes it's adjudication, sometimes it's disposition, sometimes they're combined. It entirely depends on the facts of those cases, but we drew the line roughly at adjudication. So we said in our brief, we're not challenging the adjudication order. We are talking about errors that happened post and prior to adjudication, but we're not challenging that order. So the answer to how do we undo this is we have to go back and reset her, ideally, at the point right after adjudication and give her a chance to reunify. So give her that clock that ran, give it back.
So you're looking for more than just a new trial. You're looking for services, is that what I'm hearing?
Services, reunification period, whatever needs to happen. I mean, this is then when you get into present tense best interest, we have to go back and see the children as we find them now. And this is a complicated problem that mostly needs to be sorted out by the juvenile court on a potential remand. So, but in terms of instruction from this court, that's what we would ask for, that it goes back to reversing the termination, back to the point of the original disposition, and the court reconsiders whether to order reunification services, what is the goal going to be for these children, and how are we going to achieve it? And
Okay.
then proceeds from there.
So if I were not to agree with your request that we recognize structural error here, help me see how you can show prejudice by looking at the record and by doing, the counterfactual analysis that we're usually required to do to discern whether or not there's a different result that would have been reached here.
So the easiest way to describe what the prejudice was is that it's very likely, had she had counsel, had she been participating up front, we never would have had a termination petition in the first place. That proceeding would not have happened. This is why we went to structural error, because it changes the very type of proceeding that happens after these errors. It's not just it changes the framework, it's a different proceeding. Reunification is a completely different animal than a non-reunification track.
Sure.
So she went into functionally a non-reunification track, even though the case was in a reunification posture. The court treated her non-reunification. And that was entirely prejudice based on not having representation, not being able to participate, and being excused from the proceedings. So the prejudice is extensive. She would not have been in a termination position, but for the fact that she had no due process in the beginning of this case.
In the 2023 termination order, the court does not rely or even mention the fact that she was out of the country or didn't participate in reunification services or anything else. So why would we conclude that there's a reasonable probability that that would have been different? Because you're not contesting the adjudication, right? So we're already, I don't understand why you think we would not have gotten to a permanency hearing.
A termination trial?
Sorry,
Or
yes.
Yeah.
Yes, sorry.
We probably would have gotten to a permanency hearing. That happens in reunification. So the question
Okay.
of permanency is, can we send the kids home or not?
Okay.
Has it worked or not? That's the permanency
So
hearing
you
question.
think that the permanency hearing, what would have happened if she'd had an attorney, and why would that have made a difference?
So this is a very hard question to answer because it could have gone a bunch of different ways, and that's why we went structural error. This is where we get into sort of a butterfly effect problem, where if she had had an attorney, let's say at that first hearing where she had asked for one, most likely the attorney would have said, don't go to Turkey. She may have never left. We have no idea what would have happened.
Do we need that? I mean, going back to the question about when it was originally raised at the termination trial, I assume that she could have testified, for instance, if I'd known what was going to happen, if I'd had an attorney, I wouldn't have gone. Or maybe an attorney could have put in an affidavit saying if I had been appointed earlier, I would have advised her as such and such. Do we need that here?
Do you need that evidence?
Yes.
I think the evidence is there. It's not quite so clear, but she makes clear in her testimony at the second termination trial, and even at the first to an extent, that as soon as she realized her kids were removed, she tried to get back. So obviously if she thought that was a danger, I mean, the logical conclusion is if she thought there was a danger for children being removed, she wouldn't have left in the first place. She was told, and she testified to this, she was told by the caseworker, everything's going to be fine, we just have a couple of things we want to clean up with the custodial parent dad, and we're going to close the case. It's not a big deal. She'd been through this before. So she knew what it looked like, and she trusted the caseworker. No one told her, your kids might be removed. No one told her, this is not going well. She didn't know that until after she had left.
Is that in the record? That testimony?
Yes, that is, I can get it, it's in our briefing, but yes, she testifies at, I think it's both trials, that's what she was told, that the caseworker told her that.
Okay.
It's definitely in our fact section.
So
And that,
can I ask you one more question before you move on to anything else? Explain to us how the default then plays a role. Because as I understand it, that is when she is in the reunification stream. But she doesn't know she's in the reunification stream because even though the court ordered it for her to be in the reunification stream, she doesn't have counsel yet. They're not providing services for her. Is the default then to take her from the reunification stream to the non-reunification stream, or is it the default do something else?
No, so in terms of what this court can do with a remand, the default doesn't do a whole lot. We're not undoing it. What it provides is a basis for the court's jurisdiction. So the juvenile court's allowed to insert itself in the family because of this default adjudication of neglect. In a perfect world, we would like that to be undone, but the finality rules where they stand right now, that's something we have to live with, even though that is definitely a prejudice that came out of the errors that happened in this case. So it doesn't really affect which track she goes in, other than at the point of disposition, it's a judgment call by the juvenile court, whether it's going to order reunification services or not, whether it's going to put the goal at reunification or not. That's a judgment call. And the nature of what happens at the adjudication phase absolutely informs that decision. So a parent, under normal circumstances, if a parent had defaulted in adjudication, they just don't show up. We don't know where they are, they don't seem to care. That would be a pretty good reason for a juvenile court to not put it into a reunification phase. In this case, it's obvious mom was trapped, right? She was trapped in a foreign country. She was not paying attention, she was trying to come back, she was trying to participate, she offered to participate before she left, and that wasn't made possible. So in this case, I think it would still, hopefully the judgment would dictate putting it into a reunification track. So it doesn't matter for this court's purposes, that default, it doesn't really come into it, other than it's very clear prejudice that happens against mom because of not having counsel at that stage.
And I guess that's more my question, not necessarily what we do with that, but does that compound or extend the harm or the prejudice to her because the default certificate or the default was entered?
Yes, so, and one of the major ways that I'm completely missing is that it forms a ground for termination. Neglect is a basis for termination. So right when that happened, the court handed half of the termination argument to the state. So that forms also a massive part of the prejudice analysis, that she has to now overcome that grounds finding.
So it does carry weight through the rest of the case?
Yes, absolutely it does. Yeah, these are compounding proceedings, everything matters as you go forward.
Okay.
And that's a different argument about whether findings that are sort of stale that way really should be considered. That's more of a philosophical argument about what we should be doing at the termination stage. But it all plays into why we went for structural error here and not just some straight reversible error. I mean, the errors here are the kind where if you saw this in a criminal proceeding, there would be no question. If you had a criminal defendant that went through a trial, even most of a trial, but not like maybe the very end, unrepresented, it would be a no-brainer reversal. So this is a very similar situation. It's just harder to see how it fits together because this is like one extended proceeding that happens as opposed to the termination trial, which is what we tend to focus on.
For purposes of, this question, assume that we view structural error as unavailable. You don't challenge the adjudication order. So I assume that would mean that any defects in the proceeding, lack of notice, lack of a counsel, prior to that time would be irrelevant.
Without structural error?
Without structural error.
Yes, the same errors occurred after, so it doesn't really matter for
That's the period I want to focus on,
Yeah.
is the errors that occurred after. Now, you seemed to suggest earlier that these are stale or
the finding from adjudication.
time to address them had passed. Is that because they were not preserved or because they were not appealed from at that point? Or what did you mean by that?
So the pre-adjudication ones or the post-adjudication?
Post-adjudication.
Post-adjudication is a little bit of a different universe. So she continued to have no counsel. That was one of the errors that continued to occur post-adjudication. She did not get notice of hearings post-adjudication, and she was denied a meaningful opportunity to participate in the first permanency hearing. So those are the errors that happened post-adjudication if we're looking at that world. In terms of the staleness comment was about the staleness of the finding of neglect from adjudication. So it doesn't have to do with the errors necessarily. In terms of what counsel could have done about, or what could have been done about those errors, for most of that she was unrepresented. So she would have had to know how to raise these concerns without counsel, without being there. I mean, it's a very high burden to put on a pro se parent who is just trying to figure out what is going on and do the best she can to comply with what DCFS is telling her to do. I mean, here, at this point, she is relying entirely on what the opposing party is telling her.
Was she still free to raise those errors at the two termination proceedings? Or was
Yes.
she precluded in some way by lack of preservation or expiration of any appellate period? Or what's your thought on that?
So in terms of whether her counsel could have raised, like, the post-adjudication version of this, he did. He said she was unrepresented during this, she was doing what she was told, she didn't know what was happening. So he does raise this. He doesn't raise it in a standalone motion, but that's not what's necessarily required for preservation. And in terms of giving the court an opportunity to rule on this problem, this is why we raise plain error. And these are plain errors. The court should have known that it should not be proceeding against a parent with no representation. This is not something that the parent or counsel needed to tell the court.
But as you know, counsel did reference, was in the oral argument for the second
closing.
termination proceeding, he did complain about the lack of prior representation.
He did it in both. He did it
In both.
in the first termination trial's closing argument and the second.
So why do you rely on plain error?
It's an alternative. So structural error is still subject to preservation to some extent, but plain error obviously
I mean, it
is
sounds like,
not.
why wasn't that a preservation? Why he's raising that at both termination proceedings?
Why, I'm sorry, I didn't understand the question.
He objected, he raised the question with the judge, he gave the judge an opportunity to respond to it.
Yeah, we certainly argue that is the
Okay, so
preservation.
you're arguing that
Yes,
it was appropriately before the court
yes.
and raised with the court, but even if not, we should apply principles of plain error
Exactly.
and principles of systemic error. On the structural error question, I understand your point that it's a wide open universe as to how things might have been different with a lawyer. I assume a lawyer would have been able to appear at these hearings on her behalf, even if the virtual option was not available. Is that correct? Were there any where she would have been mandated to appear
No.
personally?
And the court could have ordered that, but certainly a counsel could have dealt with that problem, could have had her appear virtually. There were lots of ways in which counsel could have mitigated her not being able to participate in most of these proceedings.
And I understand that part of the appeal of the structural error approach is that it's just hard to speculate, hard to pinpoint any one particular error. But if you were required to do so, what was the principal harm that resulted from her failure to have counsel post-adjudication order?
Post-adjudication order would have been not being able to participate in the proceedings just on its own is prejudicial. I mean, she can't defend herself. She can't tell the court how she's complying with services. The court assumed it didn't even order reunification services to mother, which was erroneous. So counsel could have corrected that and said, actually, court, you did order reunification to mom. So can you please help provide services virtually, since that's how we're providing services to everybody right now? That's something that could have happened. She could have she got back as early as she could. There was nothing anyone could do about that, but that's not her fault either. That's a global pandemic. That can't be held against her. The attorney, especially at the first permanency hearing, because there's a possibility of 2 extensions of the permanency timeline, an attorney could have said, she is working services, she is diligent about visits, she's been at child and family team meetings, she's absolutely complying with the plan. You need to extend services as to both parents, which it's a little unclear what the court actually did with that first permanency hearing. But certainly by the second permanency hearing, which she was still unrepresented at, that was key, because that could have given her another 3 months to show the court, I am here, I'm ready, I am doing everything I can, please give me my children back. So that part was extremely prejudicial to mom. Just that being unrepresented, those 2 permanency hearings alone is sufficient prejudice to be reversed.
Thank you.
What evidence is there in the record that shows a reasonable probability that if she had been represented and had been granted, let's say, virtual reunification services, that it would have made a difference? that she would have complied, that it would have affected the eventual outcome?
So actually, the best indication is the prior case. She's done this before and successfully reunified. And she said, and she explained at trial, I was the driving force behind that. I was the one that really did the motivation. She was the breadwinner of the family. Dad was more of the stay-at-home, so it's a little bit of a flip situation. And she was the one that put it all together. And even before she left for Turkey, she made sure Dad had money in the account, food stamps. She called the housing to make sure the subsidized housing was paid for. She took care of the family financially. That was her role. And she was the driving force in getting the kids back in the first case. So that's probably the best indication that that's exactly what she would have done again. Not to mention, at the second remand hearing, she shows up with a newborn infant that DCFS has no concerns about. None. And yet it's saying at the same time that this is a parent unfit to parent a 7 and 9-year-old. So that's a pretty good indication that she would have been successful in reunification.
Thank you.
Can I ask two questions? The first is, when you said that her counsel raised some of these due process concerns in his closing statement, what was he asking the court to do because of those concerns or those errors?
Not terminate.
Okay, but was it to just enter a permanent guardianship, or was he suggesting that they should go back and offer services? Or I'm just trying to figure out what was his request at the end of that hearing?
Yeah, it's a little bit unclear, but his request was, his job at that point was guarding against termination. It was sort of a binary decision at that point in time. Permanent custody and guardianship, I don't think was necessarily what he was going for. That certainly was discussed at the second one, but the first one was more, no, you can just reunify. She's fine. She's done the things, you don't know about the things because she wasn't allowed to participate, but she's done the things. She has the ability to parent. Please just give her kids back. Dismiss this termination petition and be done with it.
That was in the first, okay.
Mm-hmm.
That was the goal that he was advocating for. Why did that change into the second?
Because of the amount of time that had passed.
Okay.
And it didn't change. That was still the primary goal, to be clear. It was, reunification was still.
He was
the
still
primary
arguing
act.
for that?
Yes, it's just that at that point, we were more realistic about what would be pulling the court in other directions because of the amount of time that had gone by.
Okay.
And these are kids that are in a placement in Tennessee. It's pretty far. Despite the kids' own testimony that they wanted to come home or at least have in-person visits in Utah, there's still, it was a backstop argument to say, at least this is a permanent custody and guardianship. It is not in the best interest to terminate here because these boys want a relationship with their parent. They want to be involved in her life. They want to be involved with their younger sibling. And mom is a responsible parent. Like, she's doing all of the parent things. The biggest complaint was how expensive a gift she bought her kids. I mean, the fact that that's entering into this discussion at all is almost insulting.
Okay, let me ask, so he was advocating then, or she, I'm not sure, for the permanent guardianship in that second proceeding, is that right?
As a backup. So
Okay.
first request was, please return the children. But if you're not going to do that, Judge, at least do a permanent custody and guardianship, no termination.
Okay, let me just ask you a quick question about jurisdiction. At least I'm not sure it's quick, but we'll see where it goes. I'm struggling with jurisdiction here. I think it's possible that we have jurisdiction over the 1223 order, right? But I'm struggling to see how we have jurisdiction over anything else. It seems as though the notice of appeal that was filed relating to the first proceeding was untimely. I don't think Rule 60B saves that. And so I don't see how we get to anything that predates the 2023 order. So help me understand why you think I should.
Two answers to that. I'm going to kind of work my way backwards. So I think the easiest answer is that the 2023 order is the only final order. And the reason is it substantially changes the termination order, the 2021 termination order, and re-terminates mother's rights. So the first reversal completely reversed the termination. It was not a limited remand, the subject was just to find best interest, but it completely reversed the termination order.
Which, let me just pause you there. I agree that that's what it did, which I find quite unusual, quite frankly. But I don't think the Court of Appeals had jurisdiction to do that. So I don't think effectively they could have done that because they didn't have jurisdiction to order a reversal. Now, we went forward, right? The parties did it, the court did it, and that's why I think although unusual, we might have jurisdiction over that second proceeding, but I don't see how we get something before that.
Well, it's still, the point still stands, it can't be two final orders. Because the second order, the whole point of the court doing the second trial was because the first termination order was incomplete. It was so deficient that it didn't cover all the bases for best interest.
Okay, but didn't that become final once it wasn't appealed?
The 2023 one did. But essentially, the 2021 order just became a subsidiary order that had partial findings that the court incorporated into its 2023 order, but it re-terminated mother's rights in that order. It entered a substantially different final order on termination in 2023.
But how was the 2021 order not final when it was not appealed in a timely way?
So, all right, so if we go into 2021 timeline, we do think it was timely because although it was on a 60B, the court didn't just re-enter the termination order, it reinstated the time to appeal. It ruled that it was reinstated.
But let's say I disagree with you that
Okay.
the court has the ability to do that
So it
under
didn't
Rule
do that.
60. So I think, assume that I believe that the 2021 order was final because it wasn't timely appealed. So I think at best, you might have jurisdiction over the 2023 because there was this new proceeding, but I don't understand. I think the 2021 was final. So what do I do with the 2023 if I find that?
I mean, I guess we have to rely on, it's just, how can they both be final? How can the 2021 termination be final and then a 2023 termination be final?
Well, I
They're
think
doing the same thing.
2023 is either a nullity or you're able to at least look at that order.
So, yeah, so then I guess the option would be 2023 didn't happen and we're just going off of 2021, but that would be, in no uncertain terms, a gross miscarriage of justice.
I'm just trying to get jurisdiction settled here.
No, I know.
Right? And I think something very unusual happened, and that's why I think maybe I could recognize the 2023 order as a standalone proper order, but I just don't understand how I can go back and revive 2021 when it was final once there was an untimely notice of appeal filed.
I mean, I guess we'd have to be reversing the Court of Appeals decision at that point to remand and reverse, right? That's what we'd have to be doing?
I mean, if we did that, then I think, again, it's as though 2023 doesn't exist. I just don't think the Court of Appeals had authority to do what they did in 2021, or to get back to 2023.
Then the question is, do we have a Manning argument? That's where we get to. And the state concedes that Manning probably should apply in this case, that we should do the same thing that we do in criminal cases, where it would effectively deprive a litigant of their right to an appeal. We let that happen under the Manning precedent. So the argument would be Manning does apply in child welfare cases. It doesn't need to anymore because we have a rule for that now. So we've solved that problem. But for the narrow purposes of this case, this court should apply the Manning principle and allow that notice of appeal to be recognized as timely because of that precedent.
Okay. And do we really need to be able to review the 2021 proceeding? Or if we review the 2023, does that really get us everything that needs to be reviewed? I'm just trying to figure out if we apply a Manning remedy in some way, do we apply it to recognize the 2023 order as properly before us, or do we need it to recognize the 2021?
I guess it depends on how you view the relationship between the two orders.
Okay.
If you view them as two separate final orders, you do need to be able to get to the 2021 order because that's still a termination order, and we're asking to reverse termination.
Okay.
If you view them as one and the same order in two parts, then the 2023 order is the only one that really matters.
Okay, thank you.
Why didn't the failure to raise the due process issue in the appeal from the 2021 order waive the issue?
Sorry, say one more time.
Why wasn't the due process issue waived when it was not raised in the appeal from the 2021 order?
There was no appeal from the 2021 order.
I'm sorry.
It was
How did the
stipulated.
district court? How did the Court of Appeals then get
Yeah.
remand?
It was unusual. So it was in preliminary stages. The Court of Appeals issued a motion for summary disposition asking about the jurisdictional problem. The only respondent was Mom's counsel, who said, please apply Manning. Nobody else responded. Then counsel changed, appellate counsel changed, and at that point, in review of the case, the parties all stipulated that the best interest analysis in the original 2021 termination order was so deficient that we had to remand for additional findings, and it was a stipulated remand.
I understand that, but are you saying that council never had the opportunity to raise the due process issue
Right,
in
there was no
that
briefing.
case? Okay.
It was never, the only thing that was submitted to the court for consideration was a stipulated motion to remand for best interest. And we, in the motion, stated, this is me going off of memory, but in the motion, we stated we're not waiving any of the other claims we might have had. We just need to go back and get these best interest findings so that it can all be reviewed at the same time.
Okay, thank you.
If I could go back to Justice Pullman's question. If we assume we have jurisdiction only over the 2023 order, I'm wondering about the ways in which your argument would be limited. I think your response was, it depends on whether they're viewed as a single order or separate orders. I take it you view them as a single order.
Correct.
Do you view the 2023 order as having incorporated the first termination order in some sense?
Yes.
And what is your basis for that
The court says it.
conclusion?
The court says it's incorporating the findings from the 2021 order in the 2023 order.
The findings?
So that, we're going off what the court's saying. And also just logically, you can't terminate a parent's rights twice. So one of them has to be ineffectual. Otherwise, you've terminated the same parent's rights two times.
So if we did conclude that that incorporation was effective and further concluded that our jurisdiction was limited to reviewing the 2023 order, would that hamper you in any sense in making your arguments?
It would hamper the simple due process argument. And what I mean by simple is, taking an error isolated by itself, can we reverse on that error? Because those errors happened prior to the 2021 termination order. I don't think it completely negates the problems of structural error, because those structural errors, that sort of amorphous prejudice persisted right through into the second termination trial, because a lot of the second termination trial was still this rhetoric, the same rhetoric that it persisted all the way through of mother is uncaring, mother left, mother doesn't care about these children, she doesn't understand her children's needs. This is all a narrative that's genesis is from those due process errors, and it is pervading all the way through to the very last termination trial. Putting that aside, even without the structural error arguments, the best interest argument stands alone as coming out of the 2023 remand by itself. So all of the best interest arguments are still exactly as we briefed them. Nothing is hampered that way. It was not in these children's best interest to terminate. It was against their very well-expressed wishes to terminate their parent rights. And it was also in the face of an obviously fit parent.
Okay.
Thank you very much.
No further questions. Thank you.
May it please the court, John Peterson on behalf of the state of Utah. Obviously, this is a very anomalous case, and I hope we never see the like of anything like this again. And clearly, as Ms. Marichal recognizes, there are definitely two competing narratives. One is that this is a mother who is just completely denied due process. The other, which the state has proffered, is that this is a mother who has consistently shown very little concern for what's going on with their children. I mean, these proceedings date back to 2015. If you look back at the 2015 and again the 2019 removals, they're about the same case. I mean, in both cases, either their children wandering out in the street in their underwear. It's like, so the idea that somehow she had reformed herself in the first proceeding seems clear like it did not happen. And so we have a juvenile court then presented with a mother who shows up at the first hearing and says, well, I'm leaving the country. And, I think the court is, clearly a little nonplussed by this situation. What do you do? I mean, and I guess I guess you could order her not to leave the country, but it demonstrates a very lack of, concern about what's going on with your children. I mean, and so the notion that somehow a couple of years later she's back, she's got a new baby, she's repped it and ready. No, but what's really going on in this case, these are children who, truthfully, at both removals in 2015 and 2019 were practically feral. I mean, they're not potty trained, they can barely speak. They grunted, the one child didn't recognize men and women, the difference between the sexes. I mean, you look at the testimony from the first foster mother, Mrs. B, and she speaks about how, she worked with them. She was the first and the second foster mother, and she worked with them and started making some progress. And she's like, these aren't children that have organic problems. These are children who've been badly neglected and who did not develop properly through lack of parental care. And she started working with them, and then they were returned. They come back, and she testified, as the juvenile court noted, they're almost worse than they were before after having been returned to the parent. And and then they moved on. There's the second set of foster parents, again, continued working with them. This mother, had a full-time job that she had to quit because these children required so much of her time to take them to their appointments, work on their speech therapy, their occupational therapy. And for mothers to come in and see, I can raise a baby, I can raise these two, I can do anything. All her testimony was very flippant. It didn't demonstrate a reality of her role in creating this situation. So to say somehow that had she been appointed counsel, everything would have been miraculously different, how is that? Not here is not here. I mean, if the counsel could have informed her things are happening, you can show up, you can maybe appear at a hearing, you can figure out if the connections are good, if you have proper internet, but you're still not here.
What about their argument that if she had been appointed counsel, counsel might have advised her, you really need to stay in the country or you risk losing your children? And she might have heeded that advice. Is that too speculative? What is your response to that argument?
Clearly it's doing a lot of speculation, obviously, unfortunately. And granted, I think it would have been nice to have counsel appointed probably, then we wouldn't have to speculate. But her conduct, and she testified later on, at the termination, she knew exactly how things unfolded, that it wasn't her intent to leave the country, and she had no intent to remain in part of these proceedings. And the idea that she just had no idea that her children were going to be removed. They were removed a few years prior for the same circumstances, so it's hard for her to say, I had no idea that they could possibly remove my children for doing the same thing I've been doing the whole time, which is leaving them to the father's bad care.
And that does, I completely understand your argument on that. But going back to what the court told her at that first hearing, that she would be excused from the proceedings, that did seem, I would think that would indicate to someone that there won't be any type of adjudications that involve them or that their rights won't be prejudiced in any way. So once she returned to the country and once she was appointed counsel in February of 2021, can you tell me what could have happened at that point? For instance, they're not challenging the adjudication of neglect. It sounds like where they think it went off the rails was with reunification. When she returned and was appointed counsel, could counsel have asked for reunification services at that point and said, she hasn't been offered these services even though they were available. She wasn't appointed counsel, so she couldn't assert her right to that. Could we do it now? Is that possible?
You can ask for anything, whether it be realistic. I think, in light of her conduct of basically advocating her parental responsibility and leaving the country for an extended period of time, she comes back right at the very tail end of the reunification period. And so, you could ask, would it be likely?
That's kind of one of the problems, though, that I have with these facts is that it almost seems like she may have been reasonably led to believe that her leaving the country wasn't a problem, right? And if that's the case, then would it be reasonable for the court to say, well, you left the country? I think her response would have been, you told me I could. You told me I was excused from these proceedings. So let's just assume that the court wouldn't have denied it on that basis. Is there any legal reason or timing reason or something in the statute why, if her attorney had asked for reunification services at that point, they would have had to be denied?
No, in theory, there's the maximum period of reunification if they're extended out. It can be extended out to 18 months. With the finding that reunification is likely, I don't know how the court would make, beyond a year, every time you extend services, you have to demonstrate that that, the service has been effective and you believe that they're likely to be, the children are likely to be returned within the
Sure.
extension period. And for somebody who just wholly abdicated their parental role and left the country to come back and say that, well, I'm going to jump right back into this and within 3 months you're going to be able to return these children to me.
No, I understand that the court may have, based on the facts of this case, denied such a request. I'm just trying to figure out, for purposes of prejudice, whether the prejudice she alleges that she suffered during the time she was unrepresented was correctable at the time she was represented. Does that make sense?
Yes.
And you're saying it was an option. Her attorney could have asked to basically rewind the clock to immediately after the adjudication proceeding once the attorney was appointed?
I mean, it's possible it could have been.
I'm just asking, could he or she have asked? Not whether it would have been granted, whether they could have asked.
He could have asked.
Okay, thank you.
If you did ask, I understood from Ms. Marshall's argument that during the period of the pandemic, reunification services were offered virtually. Is that accurate?
To some extent, I mean, it wasn't ideal, but I mean, people did what they could do. I mean, I understand the COVID what it was. There were some things being done remotely, but we were and this is a weird case again. Another weird fact is that COVID sort of erupted in the midst of this case, so we were just getting these things up and running. So unfortunately, the time period we're talking about is probably where we're not at our best remote. We were trying to figure out how to make things happen as best we possibly can, and the international aspect creates a whole different problem.
Well, I probably don't have a good handle on exactly what is done in the reunification process. I assume there are interviews with the children, the mother, and
It varies from case. I mean, typically things like parenting classes. I mean, more advanced parenting classes involve the children and the parent. I mean, because obviously, if you can teach a parent things, but it's more effective, kind of more hands-on, where you're applying these things to your actual relationship with your children. Could these things have been done? Notwithstanding the time distance stuff, maybe some efforts could have been online, but I mean, it's difficult. I mean, also, we talk about these are children who, essentially didn't necessarily communicate entirely well. So, their ability to even just go on visits and stuff, she is reduced to talking about things like using filters and talking about movies and Pokemon and stuff. And so the idea that we'd somehow superimpose any kind of real structured communication training on top of these already visits that were
okay, so not optimal
would be not optimal.
to provide reunification services virtually, but roughly possible.
Yes, I think. I guess I'll just briefly address jurisdiction too. That's definitely the elephant in the room. And I mean, my speculation was that this court might consider doing something like extending Manning to this case, because I mean, clearly when people ask for counsel, they should probably be appointed counsel. In a perfect world, that would have been a good thing. I mean, I think at least you could have said, well, communicate with your counsel, at least you'll know what's going on. I mean, obviously, mother had a general idea what was happening. She knew the children had been removed. I mean, and she knew from her prior experience that was a possibility. But, without that, I mean, obviously the first notice of appeal from the 2021 termination was defective, was filed in the wrong court, and simply, I mean, they tried to reinstate it, but the case law is very clear. The court doesn't have the power just to re-enter orders, and here's another, 15 days. But and then, things got tied up, and, in the meantime, case law such as BTB came down from this court, dealing with, the strict necessity of termination, which was new, and so we all basically decided, well, the court didn't really go down that road at all, so let's send it back, and at least we don't want to go up and appeal and then go back again just for remand on BTB. But then somehow in that process, everybody kind of lost track of the idea that the court didn't actually have jurisdiction at all. So then the court entered a remand order from a deficit of jurisdiction. I mean, really, so it comes down to, it seems to me, that either this court is willing to do something Manning-like on an ad hoc basis in this case to resurrect her appeal through the re-entry of the order, or there simply is no jurisdiction over this appeal.
How could we do that? how could we do that for the 2021 appeal in this case? How could we reach back and apply Manning to make that timely when that's not what's before us?
Yeah, I mean, I guess you either have to, enter a remand for the trial court too, in this first instance now, substantially later make findings about whether the appeal was properly denied due to error of counsel. I mean, it seems from counsel's affidavit that that's pretty clear. And I guess this court could also maybe retroactively validate the court's re-entry of the order, which is the Manning-like remedy that you would get out of Manning. But I don't know what the court's appetite for doing that. I mean, it's very loose. I mean, we're definitely in very uncharted territory here, obviously.
When does the state first raise the issue of that jurisdiction from the 2021 order? Because obviously the stipulation to remand, it wasn't like, well, we don't think they have jurisdiction, but we're going to stipulate to remand anyway. So when is the first point that is raised by the state?
Well, we raised lack of jurisdiction before the remand. Because basically when the order was re-entered, basically said no. The court did sua sponte, dismissed it, then they re-entered the order, re-appealed, and I was counsel back then too, and I objected saying, that the case law is clear. The court doesn't have the power to simply just re-enter orders as many times as it feels like. And so then the court dismissed it, and then when mother's counsel responded, raising Manning, the court set it over for plenary briefing on including the Manning issue. And so the court basically punted, like, we'll figure out jurisdiction in the fullness of time with plenary briefing. And then, unfortunately, and I guess we all share a lot of blame, and we sort of forgot about the Manning issue and in the face of asking for the remand. So again, it's one of the many messy things about this case, but here we are.
So, but if we have to pick though, didn't the state waive that issue? And I get that we don't necessarily waive issues as it relates to jurisdiction when you get to this point, but if we have to find against or the responsibility for that, isn't that fall at the state's feet that wasn't properly raised or briefed, or that you stipulated after that?
I think the problem is that either, the appellate court either has jurisdiction or it doesn't. I mean, we can't stipulate the jurisdiction, and you can't waive. I mean, jurisdiction either exists or doesn't. I mean, and obviously we led the court down the primrose path a little bit on the 2023 remand, but it doesn't change the fact that the court simply didn't have jurisdiction to do what it did. I see I'm out of time. Are there more questions?
I do have another question I wanted to ask you. I felt like this was telling in your brief, and I want you to explain it. This is on page 2 of your initial brief introduction. You said, "This is an unfortunate case in many regards, and there is plenty of blame to go around." Are you conceding error? Or tell me what errors you are conceding there.
I mean, I would readily concede that these proceedings could have been handled better. And I think in a perfect world, had I been a trial judge, I think I would have maybe spent a little more time talking with mother about her options, about whether it was a really good idea to leave the country. I would have appointed counsel and said, "This is what I'm going to do. I'm going to appoint you counsel, and you may leave the country, but I trust that you should maintain contact with your counsel. That's going to be your conduit for information. I'm going to assume that you know everything your counsel knows." I don't think that would have fundamentally changed proceedings. I mean, not here is not here. But I think it would have been a better way, and I think it would have removed some of these unfortunate speculations about what could have happened had she had counsel. And that would have been better.
And what about the state in terms of DCFS? Are there errors there?
I think they did what they could do. I mean, again, the COVID era was an uncharted territory for them too, about what kind of services they could provide. And if you look at it, it's odd too that it was unclear whether the court really thought it ordered to, because the court, there's a minute entry ordering communication services, but then what the assistant AG asked for was basically said, well, we'd like to have an order for services on the chance that she comes back. We'd like to be able to kind of, get things going, and so it's sort of like a fallback. We understand that with her in Turkey, we can't do very much, but let's just, you can order it, and if she comes back, then we'll see what we can do at that point. And then the court scene, again, later on the court, during the permanency hearing, the court said, well, I haven't ordered services for you. So it appears that in the court's mind, what happened was that she decided she was leaving and didn't want to participate, and So why would we order services? I mean, maybe that belief morphed over time. Again, it's one of the many strange aspects of this case.
But the court explaining it better, the court either taking a proper waiver or appointing counsel, the communication, which I think that the record is clear, she volunteered to appear remotely. That might have been unusual at the time, but come March 1st or whenever exactly the pandemic hit exactly, that morphed quite quickly and that everyone is appearing remotely. And that should have been given, that opportunity given to her. In addition to that, she does come back, right, eventually. Yeah. Mm-hmm. And so at that point, she still doesn't have counsel when she gets back, right? And we're quite a few months past. I understand in terms of you saying not here is not here, but all of this blame, and that's the word that you use, all of the blame, none of it's on her side of the table. None of it's at her feet. And yet she's the only one that suffers the consequences, right? She's the only one that gets her parental rights terminated. So I'm not saying she's the victim here, but I'm also saying she is not the one that is creating the problem. She maybe doesn't affirmatively request some of those remedies because she, again, doesn't have counsel. But how is it that she's the only one that suffers consequences when really, and in fact, I'm not sure that any of the blame rests at her feet?
I mean, I guess I'd push J.A.C. back against that notion that she's somehow blameless. I mean, I just don't think any reasonable person, if you were informed also that your children were now under juvenile court, or threatened to be under juvenile court jurisdiction, would you walk away? Would you leave the country? I mean, and this idea, well, COVID came, I couldn't get back. Well, she didn't have the money to get back anyway. I mean, so once she left, I mean, she couldn't say that somehow I would have just jumped right back, but for COVID, because her testimony was clear. At least as of February 2020, she received a big tax return, but her new husband didn't want her to leave. So she said, well, I pushed it up to April, and by that point, she couldn't leave. I mean, so there's a lot of I mean, to say that she is somehow blameless and blame is being foisted upon her improperly, I push back against that notion.
Can I ask a question about that? So it seems like one of the threads of the 2023 order is that that mother doesn't understand her role in causing any of this, that she's not accepting responsibility for, gee, it might have been bad for me to leave the country and the care of my children who are young and are struggling. Am I reading that correctly, or was that sort of a failure to take accountability for her own role, not necessarily with the proceedings, but in choices regarding the care of the children? Am I reading that right from the juvenile court?
No, that's very much. I mean, I think the court's finding that calling her the Disneyland mom, well, not charitable, is not entirely inaccurate either. That I mean, these kids, like I said, 2015 proceeding, same kind of thing. We come back again 2019, same kind of thing. She says she's a breadwinner, but you don't get to just be the breadwinner. They're still your children. Your children can't read, they can't write, they can't communicate. She admitted it was hard, I mean, way back when it was hard for her even when they were 5 and 7. She had a hard time communicating with them. They were, yeah.
Did mother ever seem to understand, I shouldn't have left my kids? Or there were problems for my children in deciding to leave. Did she recognize that?
I don't see anything in her testimony that recognizes that was a bad decision on her part.
Okay. In that 2023, whatever it is, retrial, additional findings, was it in the land of 84-104-12 at this point? So is it at the point where in 104-12, where it says, wherever possible, family life should be strengthened and preserved, but if a parent is found to be unfit or incompetent based upon any of the grounds for termination, then the juvenile court shall consider the welfare and best interests of the child paramount. Is that where we were is that where this case was at the 2023 hearing or the 2021 hearing because she had already been adjudicated?
She'd already been, termination had already been entered in 2021, so clearly there's a finding
By
of parental
2020,
fitness.
okay. But for, assuming it's a do-over, and I'm not sure if it really was a do-over or not, but at both of those hearings, were we at the point where best interest was the paramount concern?
I think the understanding of the parties when we remanded it was for more findings on best interest and the new issue of strict necessity of termination. So it really was a finding about, was it strictly necessary in children's, under given the changes in case law that have come about. It wasn't a question really about, are we going to return these kids to you? Are you a new person? It was really, what is their best interest at this point?
Okay.
In response to Judge Snyder's question, you indicated, yes, it would have been better if she'd had a lawyer.
It always is.
But have you not in fact conceded in your briefs it was error for the court to fail to appoint a lawyer? I just want to be clear on that.
I think when you request counsel and you're not appointing counsel, it is error. I push back against the idea that it's structural error because I think that she played a role in the court's misperception that she had no intent. In her own testimony later in her first termination trial was, I had no intent of participating in these proceedings. So the court's perception of what she was doing was accurate. And I think, she had showed up a week later at a pretrial and, so I still haven't been appointed counsel. Counsel clearly had been appointed. So she, is a party to these errors. That's why we push back against the idea of structural error in that she's sort of, the architect of her own destruction here. And her own behavior kind of led the court down the path to believe that, and her conduct generally
You
had.
conceded it was error not to appoint counsel, but not structural error.
Yes.
Are there any other questions?
Can I just say that I appreciate your candor in conceding that there was error here and focusing on prejudice instead.
Thank you. And if there are no further questions, I appreciate your time.
Thank you, Mr. Peterson. Ms. Pierce?
Martha Pierce, attorney guardian ad litem for the minor children. So far, no one has presented a cogent theory for how this court can possibly have jurisdiction over the underlying adjudication order and the disposition orders that proceeded from that. That was not appealed. This court has no basis for reaching back into that. The only final order that could possibly be before this court is the termination order. And I submit that the 2023 termination order relates back to the earlier one because, as you said, the Court of Appeals had no jurisdiction to reverse the case, only to remand for further findings. So once those further findings were made, everything relates back to the first faulty notice of appeal. So given that that notice of appeal was insufficient to invoke this court's jurisdiction, that means this court's jurisdiction has never been properly invoked over the case.
What about the idea that, and please help me understand this because these juvenile proceedings are different and difficult.
Right.
What about the idea that a juvenile court has continuing jurisdiction over a case? Would it be possible, let's say it had never been appealed. After BTB came out, could the juvenile court have said, I don't think my 2021 order was complete or complied with that. I'm going to hold a new hearing and make more complete findings. Is that something that a juvenile court could do?
Let me see if I understand what you're saying. You're saying if post-termination, the court decided to go back and make more findings.
Yeah.
And it wasn't on appeal.
Right.
I don't believe the court could do that because once you enter the termination order, the parents are no longer parties and everything that precedes from the termination order is disposition regarding the child. So the court, so if you look at section 80-4 in the 500s, it talks about post-termination disposition hearings and a lot of structures so that you have regular reviews until the child is adopted or you affect the whatever the permanent goal is and then you terminate jurisdiction. So that's all disposition, that's not part of the termination.
So are you saying that after the termination orders entered, the children are still within the jurisdiction of the juvenile court, but the
For
parents-
dispositional purposes, there's no more
Okay.
adjudication going on.
But the parents aren't?
No, they're no longer parties.
Can no longer take any action that affects the parents?
And they're no longer parties to the proceeding.
Okay.
So it's all disposition, and it's all regarding the children, and it's all putting pressure on all the parties to division to affect whatever the permanency goal is for those children.
Okay.
So I submit that this court's jurisdiction has never been invoked. In the event this court says I'm wrong, this court's jurisdiction has never been invoked over the underlying adjudication order and the permanency proceedings that occur from that. I suggest that mother was in the same posture as the father in in re adoption of BB, which I mentioned in my brief. In that case, this court said we cannot reach into the underlying termination order in an appeal from to intervene in the adoption proceeding. And father was even in a worse position than mother was in this case, because in that case, father wasn't even identified as the father. Mother misidentified somebody else. I think she pointed to her brother-in-law and said he was the father. So that father had no ability to participate in the underlying termination order. And this court, I think it was in paragraph 104, which is a majority paragraph, says, well, you need to litigate that at the trial level still. Once father was in the intervention, he could have filed a Rule 60B, he could have litigated it at that point. And so when both counsels were talking about what could have happened, what would have been, this court isn't here to speculate. This court is here the record was not developed. And if the record's not developed, this court doesn't consider it. So it was on mother's counsel, once he was appointed, to develop a record and to say, just a minute, I want you to adjudicate on my client. I want this, I want that. That didn't happen. And in fact, the counsel led the court on and I have two string cites in my brief. One is all the time the counsel said, mother asked to be excused, mother asked to be excused. He continually repeated that and led the court on. The second string cite I have in my brief is about mother was not included in the service plan, mother was not part of the permanency goal. He keeps repeating that to lull everyone into thinking there's no error there. So that was not preserved.
Can you respond to the question that I asked Mr. Peterson about once it sounds today like what she's asking for is to go back to after the adjudication hearing and have the opportunity to engage in reunification services. Once counsel was appointed in February of 2021, could counsel have asked for that at that point?
Counsel could have done several things. He could have done, like this court suggested, an in-re adoption of BB, filed a 60B relating to the adjudication order, and said, just a minute, my client wasn't really adjudicated. Let's set that aside. Let's re-adjudicate. He could have asked for services. He could have litigated all the things that we're only speculating about today. And so this court doesn't have a record. We didn't have a chance it wasn't fully developed. So that's not what this court does. It doesn't hear things for the first time on appeal. As to the Manning question, first of all, that's already been resolved. The court has come up with a Rule 52D of the appellate rules. Second of all, since the time of Manning, this court came out with Cougar Canyon, which says we don't amend our rules on the fly. We do it by way of the rulemaking process. And the third most important thing is that Article 8, Section 4 of the Utah Constitution says that this court shall by rule manage the appellate process. It doesn't say manage it on a case-by-case ad hoc basis via case law. It says this court shall by rule manage the appellate process.
So to elaborate on how 52D plays into this.
Well, I'm saying that since the time of this, the rules have been amended to allow for reinstatement of the time for appeal. Even if that rule had been alive at the time of the faulty notice of appeal, it would not have helped mother because you have to take action within 45 days of the entry of the order.
Action in terms of filing the appropriate briefing, appropriate action in the appellate court, or appropriate action in the underlying case?
Rule 52D of the appellate rules says that a trial court has power to reinstate the time to appeal, but that you have to make a motion within 45 days of the entry of the final order.
Oh, I see.
So you still have to act quickly because that's important in these cases. That didn't happen. And that wasn't available to Mom, but I'm saying even if it were, she would not have qualified for that relief.
What would be the time limit on a Manning request?
What was the time limit?
A Manning request?
I don't know what the time limit was. And of course, that's a criminal case, so that would be subject to criminal rules, and they had used Rule 65B, I think. So Manning is not a really good parallel because we're talking child welfare appeals, which are governed by a different set of rules. But this court can't reach into, I already talked about how you can't reach into the adjudication. And I would suggest that everything that has happened since the first termination order relates back to that and relates back to the faulty notice of appeal. And so therefore, this court's appellate jurisdiction has never been adequately invoked, and this court's jurisdiction is limited to dismissing the appeal.
So are you saying we couldn't style a Manning type procedure for this context because we can only do such things through amendment of our rules?
I think the Constitution says you shall manage it by rule. And then since the time of Manning, this court in Cougar Canyon said, we're no longer going to amend rules on the fly. We're going to do it the normal way. So I can't see an avenue for this court to create a remedy for the faulty notice of appeal.
Okay, well, let's say we think we can.
Okay.
Let's say that we think that we're going to extend it to child welfare appeals because there's a right to appeal and there's constitutional rights at stake, and so we're going to make it similar to criminal law. Okay, so, but if we do that, can we still reach back and fix the 2021 appeal? I mean, that's one of my concerns because I don't understand how we could reinstate the 2021 appeal in this appeal.
You can't. You can't. And I would say, and I also suggest that this appeal relates back to that one because the Court of Appeals had no jurisdiction to reverse. It only had jurisdiction to ask for more findings. And then,
Pardon? How did they have jurisdiction to ask for more findings if they didn't have jurisdiction over the case?
They didn't. That's what I'm saying. So, but they proceeded as if they had.
Right, but you just said that they only had jurisdiction to ask for more findings.
Okay, putting that aside, because I had heard you say earlier that they had no jurisdiction to reverse.
Well, I don't think they had jurisdiction to do either.
Right.
So I just wanted to see if you disagreed with that.
I agree with what you said, that at that point, the Court of Appeals had no jurisdiction to do anything.
Okay.
And so that really left the trial court's action as pretty much null and void because the final order was never appealed.
Okay, so essentially we go back to the 21
Exactly.
order.
Right.
Okay.
My theory is that appellate jurisdiction has never been invoked, and no one has come up with a theory to suggest how this court's jurisdiction could possibly be invoked, and it's beyond question that there's no jurisdiction over the underlying adjudication and the disposition arising from that. And so when you look at structural error or anything else, you can't say we're going to count these errors way back here because there's no jurisdiction over that order. If you want to raise claims from the adjudication, then you appeal the adjudication, and that didn't happen here.
Can the trial court, though, or the juvenile court?
I'm sorry, I'm a little bit deaf.
Can the juvenile court, though, save that or does it save it based on, I think, what counsel indicated before, when he incorporates the original termination order in the second termination order? Does that then resurrect or revive everything that went into that?
I don't think it does because the juvenile court was acting under an invalid order from the Court of Appeals. It was acting under an invalid order. It had no power to really reopen that case. And so the only valid order would have been that earlier termination order.
So you want us to erase everything that happened or ignore everything that happened after the original termination order?
I'm saying this court has no jurisdiction other than to dismiss the appeal. Because everything that happened after the original notice of appeal was based on an invalid order by the Court of Appeals, which had no jurisdiction to make that order in the first place. If there are no more questions, then thank you for your time.
Thank you, Ms. Pierce. Ms. Marshall.
Thank you. Here's the explanation for jurisdiction. So, the trial counsel, after the first termination order, files erroneously but timely a notice of appeal in the appellate court, then realizes their mistake 3 business days later and files it in the juvenile court. There is no sense in which this would have been untimely under the current rule or under Manning, which provides 1 year for this kind of thing to be brought up. So definitely counsel could have availed themselves of whatever possible remedies were there. The rule wasn't enacted at the time, so what did counsel do? The only other thing available, filed a 60B motion saying, hey court, this was a little bit of a clerical error, can you please reinstate the time to appeal? It is not just that the court re-entered the order, the court actually ordered a reinstatement of the time to appeal. So this is a substantive ruling from the trial court, reinstating the time, which is the only remedy available. There was no rule to do this under. Then, in terms of the...
Was it unusual?
To have an untimely notice of appeal?
No, not that part. Was it unusual for juvenile courts at that time to reinstate the time to appeal?
No, because it's the only way they could do it.
And are there, I mean...
I haven't seen a case that deals with that problem head on.
Okay.
If
You
that's
say
what your
it's the
case is.
only way they could do it, but that doesn't answer the question of can they do it?
Yes, so the answer of can they do it comes with the Manning analysis. When we get to the Court of Appeals, the Court of Appeals asks about, hey, how do we have jurisdiction over this? And this is flagged, it's not like no one noticed. Sure. The guardian doesn't respond, the state doesn't respond, mother responds, and then the court kicks it to plenary presentation, as was said by the state. But at the point at which all of the parties, and all of the parties includes the guardian and the state, so both of those parties stipulated to the remand, stipulated to the jurisdiction of the court saying you can remand. Now I know you can't stipulate to jurisdiction, but when the court agreed and remanded, it impliedly ruled that it had jurisdiction. No one challenged that order. No one said, hey court, you actually can't remand. You don't have jurisdiction. You can waive your ability to challenge the Court of Appeals determination that it had jurisdiction, because it had to have ruled that.
When mother responded to the notice that it might be summarily dismissed, did she raise Manning? Was that the basis
Yes.
on which she claimed the appeal was timely, or that the juvenile court had authority to reinstate the time to appeal?
Yes. That was the basis for the Manning, the response to the summary disposition.
Okay.
Was the Manning argument. So the I mean, there's no easy answers, but the easiest answer to jurisdiction here is that this is a one-off. This is a very unusual procedural circumstance where mom's notice of appeal was barely untimely. It was a timely but filed in the wrong court, and it was immediately noticed. And then all of those arguments, including Manning, were properly and timely raised. And that's what the court went off of when it
But I want you
did the
to
remand.
clarify, it's not a one-off, that the juvenile court frequently will reinstate the time for appeal. Now, everyone seems to believe that that's invalid, but that has been done frequently and was something that was quite common during that time period, correct?
Right, at that time period. It's no longer necessary because of the reinstatement rule, so now we just use the rule. So even that procedure is sort of a nullity now, but it was at the time, that's how you did it. That's how you
What's the
reinstated the
argument
appeal.
that that's an appropriate use of 60B?
There's no other solution. Otherwise, we have constitutional deprivation of the right to an appeal when it was completely out of the control of the litigant. When mom said she wanted to appeal, in fact, had to sign the notice of appeal. That notice of appeal was filed, it was just filed in the wrong court.
And the reason why Manning applies here, but of course not anywhere else, is because of the statutory right to assistance of counsel.
Yes, and the constitutional rights at stake, yes. So like the same considerations that surround why Manning applies in a criminal proceeding. I mean, this is all the same kind of the same answer. That's why structural error should apply. We are talking about substantial rights, constitutional considerations. Like, it is sort of quasi-criminal in that way, even though it is a technically civil proceeding. So that's.
Okay. If we were to disagree with you that the district or the juvenile court had authority to reinstate the time for appeal, what is your response to the question I asked earlier about would the juvenile court have had the ability to revisit this issue and enter the 2023 order on its own initiative?
So a couple answers to that. The way the guardian describes what happens after termination would preclude the possibility of a post-trial motion for parents. So that can't be right, because it would make it impossible for a parent to file a post-trial motion, and by statute, they can. So
Okay.
that cannot be correct.
Could the state and the mother's council have just gone back to the district court after in re BTB and said, we stipulate to a new termination hearing, basically, we think that the court should go back and enter more findings? Could they have done that?
At which point?
After the 2021 was entered, let's assume that the Court of Appeals had just dismissed the appeal for lack of jurisdiction. Could the parties have gone back to the juvenile court and said, you know what, we actually think we need more findings under in re BTB? Would this court reopen the termination hearing and basically enter the order it did in 2023?
So basically, I'd done the same thing, but instead of doing it to the Court of Appeals, had done it in the district court.
Precisely.
Theoretically, yes.
I think.
See a reason why not?
Well, 16 might have allowed that.
Yeah. It would have been highly unusual, but I don't see a procedural bar to it.
Kind of goes back to what Mr. Peterson said, you can always ask, right?
You can always ask. The other problem is that it would have had to have been after a dismissal, because otherwise the jurisdiction is with the Court of Appeals. So yes.
Or let's say they hadn't filed an appeal or whatever.
Right, yeah. It's possible, but it's highly unlikely, and it certainly would have been stipulated. I don't think the state and the guardian would have stipulated to reopening a case that they had won. Okay,
but I guess what I'm trying to figure out is if that potentially solves the jurisdictional problem. Because if the Court of Appeals didn't have jurisdiction and couldn't have remanded, could the same thing have happened at the district court on its own initiative or motion by the parties? Because if so, then the juvenile court had jurisdiction to enter the 2023 order, then presumably we have jurisdiction to review that order, right?
Yeah, so I see what you're saying. Like, could the 2023 remand proceeding stand on its own properly without appellate jurisdiction?
Yes.
Monkey business. Okay. So the answer is yes. The court can do that in post-trial motion. It could have reopened part of the trial. It could have ordered a new trial. It could have ordered any of the traditional post-judgment relief had a motion like that prevailed. So in a sense, you could treat it that way. But I don't think that would be proper in terms of appellate review, because that shifts all of the standards of review and makes the nature of that second order very different than what it actually is. Because then you would be looking at it as everything's through an abuse of discretion standard, because we're on the 60B, and it's entering this new order that's supplemental findings, maybe? It's hard to know what the character would have been, but reading the order as it is, the 2023 order, what the juvenile court thought it was doing at that point in time is re-entering a termination order, or entering actually for the first time a termination order, because the previous one was reversed. So I think at that point we're engaging in a really, really speculative exercise of how could we shoehorn what happened into some kind of proper procedure, which gets very messy very quickly, and I'm not entirely sure how. I would probably have to supplementally brief that.
So you're saying, though, that if we find that the Court of Appeals did not have jurisdiction, then you lose, right? I mean, there's no other way to say that the district court regained jurisdiction over the 2023 order?
It would have to be two things. It would have to be the Court of Appeals didn't have jurisdiction and nothing that happened after the 2021 order existed.
But wouldn't that flow from that?
No, because we can decide that the juvenile court can just do that.
But that's what I was asking you, and I thought you were pushing back.
I think it's very hard for this court to do. I think there's no procedural problem with it. It just changes how this court reviews that 2023 order. Because now we're looking at it, sort of through a fictitious 60B lens, since that would be the only procedural avenue. I mean, or the court maybe sua sponte could do that, but.
I was gonna say, the court sua sponte, once
Yeah.
that decision came out, could have said, oh man, I didn't make
Yeah,
adequate findings, and I wanna go back and revisit that out of an abundance of caution. Now, it didn't happen here, but the court could have, and in some ways, the court, that continuing jurisdiction over the children does extend to mother in this case. Even though she's not technically a party, even though she technically is not the one that would have been filing a motion in the trial court, it wouldn't have been improper for the trial court, for the juvenile court judge, to address these issues.
Right.
In the same way that he did. It's just who asked.
And then what exactly did he intend to do? So then the question becomes, if that's how, let's say it's a sua sponte type situation, and the court says, you know, I'm going to redo this. The court has two ways it could do it. It could say, I'm just going to enter some supplemental findings, like I'm amending my judgment, or I am vacating my prior judgment and I'm entering a new one. And those are completely different for purposes of appellate review. And we would like it to be the latter if we're going to go this route, because that means that everything comes in, because the only final order is the 2023 order. And that's why we argued it the way we did in the first place, because that makes more sense. It makes more sense to go with the 2021 order was a sort of subsidiary order where the court makes some of the findings, but not all of the findings required to terminate parental rights, because remember, you have to make the best interest findings to terminate parental rights. It's statutory. So if the court didn't have sufficient findings to support its best interest analysis in the 2021 order, it didn't make a complete order. It didn't completely terminate parental rights. It would be against the statute.
Yeah,
So
but we can't, I mean, courts sometimes don't do what they're supposed to do, but we still recognize finality, right?
Correct.
And so we're not going to create this fiction where we act as though it wasn't final because it was incomplete, even though the time for finality had passed.
True, unless we're saying none of the appellate courts had jurisdiction, and instead this is more of a sua sponte action by the court itself.
But I'm not sure a court could sua sponte once an order is final, time for appeal is passed. I can't imagine we're going to say that courts could go back and look at their files and say, you know what, I didn't do enough here. I'm going to go open this up again and revise it. I mean, that seems to be, I mean, I get that we're all trying to figure out how to find jurisdiction here. I just think that potentially introduces a lot of kind of interesting ideas into the world to say the courts can just go back and say, you know what, parties, come on back. I'm going to do this again. That seems like not the best solution to me.
It definitely does. I think the best solution is the Manning solution, so that we preserve the appellate jurisdiction. We don't have that problem. We don't have this really strange procedural situation where we've gone through years of proceedings to absolutely no avail. And
No, I mean, there's nothing more frustrating to me than having you all here and worrying about jurisdiction, but we can't manufacture it if we don't have it. So we need to find a way to have it. So I appreciate all the attempts everyone's making to get us there. But
I think
we
the
have to be
easiest one is
careful.
Manning. I think Manning's the easiest way to do this, because it's not going to have some like ripple precedential effect, because we have the rule now, so that sort of displaces it. But it would create, essentially preserve what happened here in the right way, so that this court could reach everything it needs to reach.
What's the exact reasoning under 60B? So does the court say, so there's this 60B motion, and does the court sort of undo the judgment and then reinstate the judgment and reinstate the time to appeal? Or what's the reasoning under 60B?
So the mechanism that the court did here was to say, okay, I'm granting your relief under 60B, I'm vacating my prior order, and I'm re-entering the termination order and reinstating your 15 days to appeal.
Okay,
That's what it
under a Manning analysis.
At that point, it wasn't a Manning analysis, just straight 60B. Manning analysis was at the Court of Appeals.
Okay.
And we do also make an ineffective assistance of counsel argument, so to the extent that we're concerned about counsel not raising these issues at an earlier point in time, that's ineffective assistance. It was plainly ineffective assistance if that's what cuts off mom's ability to raise these errors going forward.
Okay,
Thank you very much.
thank you. And thank you to all counsel. We very much appreciate the briefing and the oral argument in this matter. We'll take it under advisement. We'll now take a brief recess. When we return, we'll hear the case of Deer Valley versus Olson.